The problem with today's labor law is that it stems from the 1930s, and it is based in the Industrial Revolution workplace. Its outdated prescriptions are for a different economy, and they do not address the individuality and the flexibility that today's workers want. The following suggestions empower workers to work how they want, with whom they want, and in a way that is best for them and their families, creating modern labor policy for a workforce. Many of these can be found in Senator Scott's Employee Rights Act, which is a compendium of the best pro-worker labor ideas in Congress, as well as several other bills that have been already introduced here in the Senate or in the House of Representatives. First, workers should have the ability to work for themselves without government mandates putting them in a box. Senator Scott's Employee Rights Act and Modern Worker Empowerment Act provide a better test for who is an employee versus who is a freelancer or an independent contractor. Additionally, Chairman Cassidy's Unlocking Benefits for Independent Workers Act and Senator Paul's Association Healthcare Plans Act would further health and retirement security of independent contractors, allowing them to get benefits from their clients without the fear of being categorized as an employee, or simply band together to get more competitive health care. When it comes to unionization, workers should have a say on their representation, or if they want to be under a union's collective bargaining agreement. The Employee Rights Act and the Workers' Choice Act allow unionized workers in right-to-work states to opt out of a union contract and represent themselves. Additionally, it would free unions from having to represent people not paying them, something which I know that members of this committee have expressed concerns about in the past. Workers' choice allows workers to say no thanks to unwanted representation and unions to say goodbye to workers not paying them. It is truly an idea that can address all sides of the labor debate and could be a showcase of bipartisan reform. Next, for workers that are unionized, every worker should have a say on who represents them. Currently, almost 95% of unionized workers have never had the opportunity to vote on the union at their workplace. Representative Onder's Worker Enfranchisement Act would require a quorum of workers to vote before a union is given exclusive representation to represent all employees in a unit. It would also protect workers' right to a secret ballot, similar to the Employee Rights Act, making sure that employees can vote in private in unionization elections, eliminating potential coercion and intimidation that comes from so-called card check organizing, where workers can be organized by open petition without the protection of a private vote. Once workers select a union, they should have the easy ability to remove the current union at their workplace, select a new one, or go without a union. Changes should be made to address the contract bar, which limits when employees can petition, change, or remove their union. During an election, worker privacy needs to be protected. The Employee Rights Act puts employees in control of what personal information is given to unions. Additionally, workers deserve to know if they are speaking to someone who is being paid to influence their decision on unionization. Representative Owens' Start Applying Labor Transparency, or SALT Act, ensures that workers know if they are speaking to a union organizer posing as an employee. The SALT Act requires so-called union salts to file the same reporting requirements as consultants that management hires to talk to employees. Workers deserve to know if they are talking to someone that is paid to persuade them on unionization, whether it is management or a union. Finally, workers deserve to be protected from harassing and discriminatory language in the workplace, no matter the scenario. Another provision in the Employee Rights Act closes a loophole created by the National Labor Relations Board, which allows harassing and discriminatory language that could even violate Title VII of the Civil Rights Act to be used during union activity. Again, I applaud the committee on looking for pro-worker solutions to address the needs of today's workforce and entrepreneurs.